Article 2 of the regulation states that members of a guerrilla force would be regarded as belligerents. They rose up before being occupied, carried arms openly, and respected the laws and customs of war. Right? They would then be accorded the rights of being a prisoner of war. Right? However, there was no right to resistance once you were occupied. So occupied inhabitants could not be allowed to attack the occupiers' lines of communication, because without lines of communication, right, an army cannot exist. So any provisions that protected citizens would depend on the citizens being peaceful. As soon as citizens cease to be peaceful, as soon as the Palestinians, for example, cease to be peaceful, then it's open season, right? Because if the citizens do not remain peaceful, right, the guarantees will lose their whole reason for existence. 1949, Geneva Conventions come along, and they do little to change these requirements, right? If you're a part of an organized resistance movement, you have to distinguish yourself, right? You have to have a distinctive sign. So guerrilla warfare, regular warfare had been comprehensively considered and regulated well before the 1970s, and the law was clear. If you're a combatant, you had to distinguish yourself if you wanted to avail yourself of the protections of being a prisoner of war under the Geneva Convention. Citizens who became involved in the war outside these strictures were liable to be executed, and the rest of the population was liable to reprisals. So you don't have much protection for civilians. Right? The only clear provision is found in Article 25 of the 1949 Hague Convention. It prohibits the bombardment of undefended towns, villages, dwellings, or buildings. But if these places are filled with enemy fighters, such as the situation in Gaza, right, you can bomb away, right? So attacking forces had to warn the besieged city of an impending bombardment if possible, which is how Israel is conducting this war.